welcome back to Litigation Help. My name is Heather Hui-Litwin, and today our topic is on mistakes. As you know, court procedure is pretty complicated, and it's fairly easy to make mistakes, especially if you're a sub rep or if you're a junior lawyer. So today, I want to ask our regular guest, civil litigator Dan Rosman, to give us a few tips on what to do when you made a procedural mistake. Dan, welcome back.
Thanks, Heather. I'm happy to be back. I love doing these videos with you, so thanks for having me.
All right, let's start with pleadings. Okay,
Okay.
so let's say that I'm a plaintiff and I've filed in a statement of claim at the court. Like, I mean, I went to the court and I'm issued a statement of claim. And now I realize, oh my goodness, I forgot to add a party, or oh my goodness, I forgot to add, another clause or what have you. So when you've submitted your claim to the court, is it final or can you change it?
So you can change it, right? And you usually will change it through the course of a proceeding. You're going to have the pleading stage, and then we get to the discovery stage, and then we go to trial. Now you'll learn things from the beginning to the end that you might want to add to your
Yeah.
your pleadings, right? And I think it's first it might be easier to understand amending pleadings if we understand what the point of pleadings are. Okay. So there's two main reasons to have a pleading, right? So let's say statement of claim, like we're talking about. The first reason, let's just say, we're not going to talk too much about it today, but when you actually get to trial, the only thing the judge is really going to read before the trial starts are the pleadings. So the judge will understand what the trial is what trial is going to be happening in front of them that day, right?
Right.
If, you're suing this person suing that person because they didn't pay the contract and all that stuff or whatever it is, right?
Right.
That's one reason. And the other reason is when you sue someone, they need to know what you're suing them for, right? They need to know all the things you're suing them for. And on the other side of that, when they put in their defense, that plaintiff needs to know what defenses they are relying on.
Right.
Okay. So it's all about notice. So when you are saying, I'm going to be suing you for this, that, or I'm going to be defending your lawsuit for this, that has to be in the pleadings. And that changes, right? As the case goes on, as you learn new things and all that stuff. So with those important concepts in mind, that should help guide you to know if you should amend your pleadings. And we can talk about now how to amend your pleadings. So it's not always because of a mistake. It might be because you just learn new things as time goes on, right?
Mm.
So to answer your first question, though, which is a little scary, is adding a new party.
Yeah, that.
That's a little scary one because, as you know, in Ontario we have the Limitations Act, and different kinds of proceedings are governed by their own limitation periods. And sometimes when you learn a little too late about another party, or you wait a little too long to add another party, you might get yourself in trouble because of those limitations acts, right?
Right.
But if you do discover a new party, if you go to discoveries and you learn, oh, it's not just this person that caused my damage, it's someone else,
Right.
you can amend your pleading to add that person in. And then there's a process of how to do that in the rules.
Okay, so it seems to me that the procedure to amend the statement of claim, it's a little bit different depending on what stage you're in. So, for example, like let's say you just went to the court yesterday, right, to issue the claim, and then the next day you kind of realize, oh, I meant to, add the other party, whatever it is. Now you haven't even served the other side, so technically, I would imagine that in this scenario, it would be pretty easy, right, to just go back to the court and say, oh, hey, I want to file in this one. I want to issue this claim, not the one I issued yesterday. Can you do that?
Yeah. So the way the rules for amending your pleadings are just like any other procedural issue in court, found in the rules of civil procedure.
Right. Okay.
Not any other issue in court. Most other issues in court, because there's always things that are a little more complicated. But Rule 26.01 and .02 talk about when you can amend your pleadings and how you can amend your pleadings. So here we are. This is Rule 26, and just so that you're aware, the website that I'm on is CanLII, and you can link to that. And this is the CanLII has this great explainer of the rules of civil procedure. So I'm on the explainer page now, right? So here's Rule Point 2602. If you can see my mouse, it says a party may amend the party's pleadings, and it gives you 3 different situations where you can amend those pleadings. Without leave, and leave means without permission of the court.
Okay.
Before the close of pleading. So that's what you said. That's what the example you just gave. Well, I filed my statement of claim, but I haven't served it yet.
Yeah.
Even if you have served it, and there's another rule that you can look up yourself. I'm not going to take you to it now, but it tells you when pleadings are closed.
Right.
And it's usually, I can't remember, it's a few days after the statement of reply, or 30 days after the defense, or whatever it is. You can go look it up yourself. But so before the close of pleadings, you can amend your pleadings as long as it doesn't necessitate the addition or substitution of a party. Okay? So if you remember what we just spoke about before, we said, look, I've got to tell the other side what I'm suing them for. Right? So if, let's say, Heather, you're suing me because I made a bad video for you or something.
Yeah.
Then you could say, well, Dan made a bad video and he said at the beginning that this and that was true. But now you want to add, I also said at the end that something else was wrong or something, right? That you can amend that, you can add that in without leave or without consent, as long as pleadings aren't closed. But if you want to sue someone else about helping me give you bad information in the video or whatever it is, then you're going to need to move to B or C under Rule 26.02. Okay?
Interesting. Okay. Wow.
So now so let's take a look at B. So B is usually used after the close of pleadings, right?
Yeah.
So maybe after you've had discovery, you realize, well, there was a couple other things happening. Maybe there's someone else you want to add. So you can get consent from the other side, right? You can say, look, I want to amend my pleadings to avoid the cost of a motion and those type of things. I want to amend it, please consent. You fill out, you create a form of consent, you get that other side to sign it, you file it with the court with your amended pleadings. And then C is asking the court for permission. So if the other side doesn't allow, it won't give you consent, then you can make a motion to the court and ask the court to allow the pleadings to be amended. And there's like a few legal tests about how what the court will consider when doing that, such as prejudice, things like that, right? And maybe that limitation issue stuff that I was talking about before. So when you want to amend your pleadings, you take a look at Rule 26.02 of the Rules of Civil Procedure.
That sounds good. This is a really excellent resource, and for our viewers, I will have the link for you to click on so that I will take you there right away.
Okay, civil procedure and practice in Ontario.
Okay, yeah, there you go.
How do you actually what do you do to amend your pleadings?
What do you do?
What does an amended pleading look like? What do you do? Okay, so I'm going to share my screen again.
Yeah.
Okay, and here I've got a statement of defense, if you could see it here. Okay.
Yep, I can see it.
Okay. So I'm not going to read the statement of defense to you or anything like that, but I'm going to just show you what we need to do. So let's pretend that paragraph 3, for some reason, we in our amended our new amended document, we want to get rid of the first few words. Right. I mean, paragraph 3 is a bad one. We never do. Let's do paragraph 4. The plaintiff, Joe Smith, is a former member of the board of directors. Let's say we made a mistake and he never was a member of the board. Right. So what we have to do is strike that out. Right. Do that easily in Word up here. So now that's struck out. Okay. Okay. And we want to add that Joe Smith is a current member. I'm just making this up as we go, right? So he is a current member. Right. Now, how do we tell the court or tell the other side that this is the part that has been amended?
Yeah.
We underline it. Okay?
Yeah.
Underlining it signals to the court, but
Ah,
signals to the reader that this is
yeah.
amended part. And this is in the rules. Okay? This isn't just what
Oh,
I'm telling you is good practice. This is in the rules of civil procedure, is how you're supposed to do it. Okay?
right.
So the rules get a little more complicated. If you're making so many amendments that you're going to have cross-outs
Yeah.
and underlines everywhere, you actually have to file something called a fresh as amended pleading or statement of claim, statement of defense, which you just rewrite the whole thing and you call it fresh as amendment. Sorry, fresh as amended. But that is just something people should know. And another thing to know, to take away from this is
Yeah.
when you're doing a pleading that is not amended, never underline anything
Oh,
because underlines are saved for amendments.
oh my goodness. Okay. That's a good point. Oh, it's good that you brought this up.
Right.
So you know what that just reminded me of is that so if in the original first statement of claim, that actually never gets removed from the record, right? It pretty much stays there in the record. So if you file something, it pretty much stays there, like in the box.
Well,
Right?
it will say in the box, if you have a fresh as amended statement of claim, like I said, if you have too many underlines and too many crossouts,
Yeah.
they'll be gone. You'll just do a fresh one.
Oh, then that will be a fresh
But
one.
that original one will still be in the record, right? It'll still be something that's part of the case, and if for whatever reason some party wants to file it, they will be able to.
Oh, that's so interesting. Okay, sounds good. So yeah, that's something new. Yeah. So don't underline something because underline is saved for the new
Amendment,
part, so that it
right.
can signify to someone that that's the new part. Anything else that you want to add for while we're still
No,
on
I think that's it. I mean, the only thing to just remember is amendments aren't just for mistakes.
right,
They're for changes as well. I mean, people amend pleadings all the time.
right.
So it's not something that you have to be scared of. If you have to do it, just do it. That's what the rules are there for, and there's a way to do it. And
I
that's
heard
how.
somebody, one of my lawyer mentors mentioned that you could even amend the statement of claim at the eve of trial. Is that
Not
true?
even at the eve of trial, at the trial.
Oh, even
There's
after trial, you can do
rules.
that. Oh,
Yeah, there's rules about how that works. You
mm.
don't have to file a new amended claim. The judge will write it in the record. That's part of the
Oh,
rules of procedure when it happens at trial because uh, the judge can only provide the relief that is being asked for in the pleadings, right? So if you go to trial for something and it's
yeah.
what you're asking for is not in the pleadings, you don't get it.
Uh-huh.
But anyone who's been through a trial before knows crazy things happen, things come out, information comes out
Right.
that might need to go in the pleadings during the trial.
During,
And there's
yeah, okay.
right.
Oh, that's so interesting. Well, thanks. Okay, that's great. So